de Derechos Humanos les da la bienvenida a la audiencia pública sobre los derechos humanos y las prácticas de contratación laboral bajo el programa H-2 en Estados Unidos. Me acompañan en la mesa la comisionada vicepresidenta primera Tracy Robinson y relatora para los Estados Unidos, así como el comisionado expresidente Felipe González y relator para migrantes y otras formas de movilidad humana. La comisión saluda tanto a la digna representación de las peticionarias como también a la digna delegación de los ilustres Estados Unidos de América. Tiene la palabra las representantes de las peticionarias por un espacio de 20 minutos.
Good morning. My name is Suniti Mehta, and my colleague Elizabeth Freed and I are representatives from the University of Pennsylvania Law School's Transnational Legal Clinic. We are here today on behalf of Centro de los Derechos del Migrante and our partners AFL-CIO, the Southern Poverty Law Center, and Fundar, Center of Analysis and Research. We thank the Commission for granting us today's hearing on violations of international human rights in labor recruitment practices under the H-2 Temporary Worker Program. We also thank the United States government for participating in today's hearing, which comes at a time when guest worker programs are playing a central role in the debate over comprehensive immigration reform in the United States. We acknowledge the commitment of the Commission and OAS member states to protecting the rights of migrant workers and their families. However, significant work must still be done to ensure that the human rights of workers under the H-2 program are adequately safeguarded. The systematic exploitation of these workers is highlighted by CDM's pioneering report, Recruitment Revealed, as well as The American Dream Up for Sale, a report authored by the International Labor Recruitment Working Group, of which CDM is a member. For decades, the United States has relied on temporary worker programs to address labor shortages in particular industries. The H-2 visa program was established in 1943 at the same time as the Bracero program, which was a bilateral agreement with Mexico to admit experienced farm workers into the United States. The Bracero program is remembered as a form of legalized slavery in which millions of Mexican workers were exploited and had few enforceable legal rights. Even after the United States terminated the Bracero program, the H-2 worker program has continued to systematically violate the human rights of migrant workers and subject them to a system of forced labor. Today, under the current H-2 temporary worker program, U.S. companies recruit migrants to fill seasonal and temporary positions in unskilled and low-wage work in forestry, agriculture, construction, service, and other industries. More than 100,000 workers are recruited under this program each year from more than 58 countries around the world. Between 71% and 83% of these workers come from Mexico. Though these laborers are called guest workers or temporary workers, they are neither treated as guests in this country, nor do they perform exclusively temporary work. Their positions may be irregular or seasonal, but the work they do is essential to the U.S. economy and a permanent part of the U.S. job market. The highly complex recruitment supply chain, which involves numerous contractors, subcontractors, and foreign-based recruitment agencies, has led to pervasive violations of human rights that are guaranteed by the American Declaration, the International Covenant on Civil and Political Rights, and the International Convention on the Elimination of All Forms of Racial Discrimination. Specifically, these abuses violate the individual's rights to work and fair remuneration, liberty and personal security, equality before the law, and access to counsel. Furthermore, the H-2 program fosters a system of institutionalized discrimination on the basis of national origin in violation of CERD. As a result of insufficient government oversight and regulation by the United States and source countries such as Mexico, workers are charged illegal and exorbitant recruitment fees and are subjected to predatory lending practices in order to pay those illegal fees. Workers are often required to pay extremely high interest on those loans and are forced to give up essential property like their homes and automobiles. In many cases, because employers and recruiters do not pay workers the amount promised or contracted for, and do not reimburse pre-employment costs covered by workers in violation of U.S. law, many workers are left financially ruined. Often, employers fail to provide written contracts to workers at all, thus frustrating the ability of workers to enforce their legal rights in court.
To illustrate the pervasive of the more than 220 individuals surveyed by CDM, 1 in 10 reported paying a fee for a job that did not exist. 58% reported paying a recruitment fee. 52% of workers were not shown contracts at all. 47% took out loans to cover pre-employment expenses that their employers were legally required to pay. Moreover, because workers are unable to secure counsel due to funding limitations on legal aid in the United States, they often do not have access to avenues for legal redress to hold recruiters or employers responsible. In addition, workers who face retaliation for asserting their legal rights or who want to leave their employment risk losing their legal right to be in this country because their visas are tied to their jobs. These abuses can result in a system of debt bondage and forced labor, recognized under both international and domestic law as a form of human trafficking. Today, we will hear from witnesses who will shed further light on the pervasive human rights violations committed against H-2 workers, from the early stages of recruitment until long after their arrival in the United States. In light of the transnational nature of the violations highlighted in today's hearing, we respectfully request that the Commission issue recommendations that promote better coordination between the United States and other OAS member states in protecting internationally recruited workers' interests through more transparent regulation and enforcement of the H-2 recruitment system. We also request that the Commission convene a working meeting during the next period of sessions on the H-2 recruitment process to work towards development of transnational strategies for addressing the rights of migrant workers on temporary worker programs. Finally, we request the Commission work to ensure that workers' perspectives and experiences are fully incorporated into regional and international discussions pertaining to migration and migrant workers. First, we would like to share with all of you the testimony of Mr. Don Leonardo, a Mexican H-2B worker employed in the fair and carnival industry who has personally experienced the human rights abuses previously discussed. Unfortunately, Mr. Leonardo was not able to travel here today from Mexico to testify in person, but we would therefore like to share his pre-recorded, translated testimony provided at CDM's Taken for a Ride report launch on February 20th, 2013 at the National Press Club.
The file is also on the flash drive. If you go to that folder on the sure.
Yeah.
Estatales de empleo de Zacatecas para venir nuevamente a los Estados Unidos.
The last time I came to the United States, I was responding also to
La última vez que yo vine a los Estados Unidos fue en el 2007, que fue donde se me hizo una invitación también por medio de las oficinas estatales de empleo de Zacatecas para venir nuevamente a los Estados Unidos.
The last time I came to the United States, I was responding also to a call from the employment agency of the state of Zacatecas to come once again and work in the United States.
Cuando nosotros acudimos a la ciudad de Zacatecas, a las oficinas de empleo, Nosotros fuimos a ver de qué se trataba el trabajo y nos dijeron que no sabían. Ahí nada más nos mencionaron que eran 3 empresas, que una venía haciendo yardas, otra ladrilleras y juegos mecánicos.
They told us there that they weren't sure exactly what we'd be doing. We might be doing yard work, we might be doing brick work, or we might be working on carnival rides.
Nosotros aceptamos la oferta, ahí empezamos a tramitar nuestros documentos, que fue el pasaporte, derecho a visa, y continuar con el viaje.
So we agreed to the invitation, and we started to work on our passport and our visa and on making preparations for our journey.
En la ciudad de Zacatecas nos habían mencionado que veníamos ganando entre $7.50 y $8 la hora. A nosotros nos pareció un salario, pues, bien.
In the office in Zacatecas, they told us that we'd be earning about $7.50 or $8 an hour, and we thought that sounded okay.
Cuando llegamos a la ciudad de Monterrey, por la visa, allí se nos otorga la visa y ahí es donde nos dicen a qué trabajo íbamos y a dónde y cuánto íbamos ganando. Ahí se nos habla ya no de horas, sino por quincena, $500 por quincena.
So we went to Monterey, we got our papers worked out, and that's when they told us what we'd be doing and how much that we were going to be paid. And now they're not talking about hourly work anymore. They said we'd be paid $500 every 2 weeks.
De allí nosotros decidimos caminar a los Estados Unidos por la cuestión de que también nos prestaron dinero a nuestras familias para hacer estos trámites, y entonces no nos quedaba otra alternativa más de que seguir adelante.
We decided to go ahead because we'd borrowed money from our family members, and we felt like we had no alternative but to go ahead with the plan.
Cuando veníamos al rumbo de los Estados Unidos, se sube con nosotros un representante. Allí desconozco yo si era representante del reclutador o de los patrones.
On the plane to the United States, there was someone that got on with us, and I don't know if he was a representative of the recruiter or of the company that was hiring us.
Cuando nosotros llegamos con los patrones, allí nos entrega él y nos dan la bienvenida y les entregan los documentos a los patrones y no a nosotros. Entonces ahí nosotros nos sentimos sin ningún documento.
But when we got there, he presented us to the boss, and he basically turned all of our passports over to the boss, and we felt like there we were, undocumented.
En ese momento los patrones a nosotros nos dan $20 a cada uno de nosotros para que comiéramos durante el día mientras agarrábamos cheque o la quincena.
We were given $20 in cash to get what we needed during the day while we were waiting for our paychecks.
En cuestión de las jornadas laborales, para nosotros era mucho el tiempo trabajado con ellos. Empezábamos a trabajar a las 8 de la mañana, a hacer limpieza en el patio, como recogiendo basura. Después nos daban media hora para almorzar y enseguida continuábamos limpiando los juegos mecánicos o lavándolos.
We also had very long work hours. We started in the morning cleaning up the carnival area. We had a short break for lunch, and then we went back cleaning up the rides and preparing for the fair.
Parábamos a las 2 de la tarde para comer, hacer de comer, bañarnos y estar preparados para que iniciara la función a las 4 a 12, 1 de la mañana, sin parar.
So then we had a break from about 2 to 4 in the afternoon to be able to bathe and to get something to eat. And then the fair started at 4 in the afternoon, and it would go till midnight or 1 in the morning without stopping.
En cuestión de viviendas, también para nosotros no fue una vivienda digna por la cuestión de que no traía los servicios adecuados, que viene siendo aire acondicionado, refrigerador, estufa, cocinábamos afuera, para lavar la loza, lavábamos afuera. Para ir al servicio sanitario, pues había letrinas movibles, una traila que también la compartíamos alrededor de 30 a 35 compañeros para bañarnos.
Our living situations were also very difficult. There were no adequate appliances. We didn't have air conditioning or refrigerator. We didn't have a kitchen, a stove that is to be able to cook. So when we wanted to cook, we cooked outside. When we wanted to wash dishes, we washed dishes outside. There was another trailer that had bathroom facilities, but it was shared with about 30 other workers.
Entonces ahí es cuando nosotros como compañeros nos juntamos, comentamos y decidimos regresarnos a nuestro país por la cuestión de pagos, de viviendas, en cuestión de pagos. A final de cuentas, nosotros nos quedaron $240 por quincena, viendo, o sea, habíamos trabajado 17 días y nos los pagaron como una quincena.
In the end, we decided to go back because of the pay and because of the working conditions. In terms of the pay, we ended up earning about $240 instead of the $500 that we were promised. It was also a 17-day, 2-week period as opposed to an actual 2-week period.
Entonces, ahí como compañeros, nosotros determinamos que nos teníamos que regresar a nuestro país para seguir trabajando en nuestro país alrededor de 3 a 4 meses para nosotros poder pagar ese dinero que nos habían prestado nuestras familias.
So we decided to go back to our countries, even though we would need to work 3 to 4 months to pay back the money that we had borrowed from our family members.
Este es mi testimonio que yo acabo de contar, frente a todos ustedes. Espero me hayan escuchado y que esto sirva para bien de todos nuestros compañeros y nuestros connacionales. Muchas gracias por su atención.
So this is my testimony. I hope that it will help to improve conditions for my fellow workers in my country. So thank you.
We will next hear from Ms. Micah Jones, Executive Director of Centro de los Derechos del Migrante, the first transnational migrant workers' rights organization based in Mexico and whose advocacy efforts have mobilized workers and their supporters to engage in dialogue around the human rights abuses of the H-2 recruitment process.
Good morning, and thank you, Commissioners. Today you have heard that workers recruited for jobs in the United States with H-2 visas are discriminated against, charged high recruitment fees, and lured by lies and false promises. These abuses may lead to situations of forced labor and human trafficking. We appreciate the presence of the U.S. government agencies that are here today and recommend that they institute regulatory, policy, and process changes to bring transparency and accountability to the recruitment process for H-2 workers in order to prevent those abuses. We also urge the agencies to coordinate their efforts and to enforce any existing protections. As we heard from prior witnesses, workers pay high recruitment fees to get jobs in the United States. In order to pay those fees, workers borrow money and become susceptible to debt bondage. While the Department of Homeland Security regulations currently prohibit the paying of recruitment fees, the fee ban is not effectively enforced and disincentivizes workers from coming forward about recruitment abuse. If a worker does come forward, the job the worker was recruited for may be canceled, and the worker will lose her opportunity to work for the employer and may not even recover the fees that she paid. The Department of Labor and the Department of Homeland Security must clearly ban recruitment fees and enforce those fee bans. Those fee bans must provide protections for whistleblowers, not disincentivize workers from coming forward. The government must also hold employers and recruiters liable for recruitment abuse, including discrimination in recruitment. Second, the government must create a recruiter registry and make information about employers and recruiters publicly available so that workers can avoid fraud. Currently, workers have no way of verifying whether a recruiter is telling them the truth. They must trust that the recruiter that the job exists, that they'll be paid what the recruiter is promising, or that they'll be working where the recruiter has promised. Workers should have the right to know where they're going, what industry they'll be working in, and what they'll be paid. They must be given a copy of their employment contract and information about their rights at the time of recruitment. While the U.S. Department of Labor has made modest efforts to address recruitment abuse in the H-2B regulations by making certain information public, those regulations are enjoined and not currently enforced. DOL must issue interim regulations to resurrect some of the proposed recruitment provisions to ensure that H-2B workers are protected in the recruitment process. The provisions that would have given workers a right to receive a copy of their contract, that would have required employers to inform recruiters that they cannot charge recruitment fees, are essential. And if workers' rights are violated in recruitment or on the job in the United States, the government must allow workers to change employment. Workers have told us that they feel forced to labor in jobs where their rights are being violated because of the recruitment-related debts they have taken on back home. Finally, workers must be allowed to access justice. They must be given immigration relief to pursue violations of their rights and must have access to federally funded legal services. Our group has additional recommendations, and we would be happy to address those in the question and answer period.
As you've heard and as we've illustrated in our written submissions, hundreds of thousands of workers will continue to be subjected to the exploitative practices without adequate oversight and enforcement mechanisms. In light of the transnational human rights violations committed against H-2 workers, again, we request of the Commission that it issue recommendations to bring the United States and other OAS member states into compliance with their international human rights obligations. We also respectfully ask the Commission to convene a working meeting during the next period of sessions on the H-2 recruitment process. Finally, we request that the Commission again include the perspectives of migrant workers in regional and international discussions pertaining to human migration. Thank you again for the opportunity to discuss these issues today and your continued commitment to protecting the rights of migrant workers.
Thank you very much. I just wish to indicate the President has asked your indulgence because the matters relate to Mexico in part. I've taken over the chair, so just to indicate. Can I invite the State and Deputy Permanent Representative and your delegation to respond?
Thank you very much, Madam Chair. Distinguished Commissioners, Petitioners, members of the public, and Secretariat colleagues, my name is Lawrence Combiner. I am the Deputy United States Permanent Representative to the Organization of American States, and I am pleased to be with you this morning. As I had the pleasure of noting yesterday afternoon before I turn the microphone over to my colleagues, I would like to take a moment to reiterate the United States government's firm commitment to the inter-American human rights system. The defense and promotion of human rights is one of the bedrocks of the Organization of American States, and we must, as member states, remain steadfast in our support. Consistent with this strong support for the Commission, including in the ongoing process of dialogue focused on reform and efficiency, my delegation is pleased to be here today to discuss how our government addresses the issue of H-2 labor recruitment practices in the United States. I would like to begin this discussion by introducing our distinguished experts on the matter who will be presenting on behalf of the United States government. To my immediate left, I would like to introduce Mr. Jason Levy, who serves in the Office of General Counsel at the United States Department of Homeland Security. To his left is Mr. Michael Hancock, who serves as Assistant Administrator for Policy in the Wage and Hour Division of the United States Department of Labor. And we have with us at the end of the table Mr. Patrick Walsh of the U.S. Department of State. He is the Director of the Bureau of Consular Affairs Visa Office in its Field Post Liaison Division. Distinguished Commissioners, I will now turn the floor over to my colleagues to make their presentations. We look forward to a constructive discussion of this important issue. Mr. Levy, you have the floor.
Thank you. As noted, my name is Jason Levy. I'm with the Office of the General Counsel's Immigration Law Division at the Department of Homeland Security. The United States appreciates the contributions that H-2 workers make to our economy. Both the H-2A and H-2B programs have significant labor and immigration protections built into the system, designed to deter and eliminate labor exploitations, which I will describe. Several DHS component agencies are involved in administration of the H-2A and H-2B temporary worker programs. Petitions for H-2 non-immigrants are filed with U.S. Citizenship and Immigration Services, USCIS, one of the DHS component agencies. USCIS adjudicates H-2A agricultural and H-2B non-agricultural petitions filed by petitioners with a certified temporary labor certification application issued by the United States Department of Labor, DOL. Pursuant to statute, the H-2B classification is limited to 66,000 new workers per fiscal year. USCIS is responsible for maintaining the count of H-2B petitions filed to ensure statutory compliance. The H-2A classification has no numerical limitation on the number of petitions approved annually. Admission into the United States of H-2 workers, who with only limited exception will require a visa issued by a U.S. consulate, is conducted by a U.S. Customs and Border Patrol CBP officer at the port of entry. Should the H-2 worker violate his or her status, the U.S. Immigration and Customs Enforcement, ICE, may place the worker into immigration removal proceedings. The Wage and Hour Division, WHD, of DOL is generally responsible for investigation of potential violations of H-2 petition conditions, for example, those relating to wages, housing, and transportation, and enforcement of the H-2A and H-2B programs. Excuse me. In late 2008, USCIS published revised regulations which went into effect in January 2009 regarding both H-2 programs designed to, amongst much else, increase H-2 worker protections. In particular, DHS regulations now require USCIS deny or revoke an H-2A or H-2B petition if it is found that the petitioner or other entities or persons involved in the H-2 worker's recruitment or employment process collected a job placement fee or other compensation from the foreign worker as a condition of employment, regardless of whether such person or entity is located or situated in the United States. The H-2 petition must be denied or revoked if already approved, unless the petitioner can demonstrate that prior to filing the Form I-129, Petition for Non-Immigrant Worker, the petitioner either fully reimbursed the foreign worker, where such fee or compensation has not yet, or where such fee or compensation has not yet been paid by the foreign worker, terminated the agreement to collect it. Similarly, if the petitioner knew or should have known that an entity or person involved in the foreign worker's recruitment or employment process collected or entered into an agreement to collect a prohibited fee from the worker, the petition must be denied or revoked. Denial and revocation can be avoided, however, if the entity or person fully reimburses the foreign worker, the agreement to collect it is terminated before any fees are paid, or if after the petition is filed, the petitioner notifies DHS within 2 workdays of obtaining knowledge of its collection. Other protections afforded H-2 workers by DHS regulations include, first, when USCIS revokes an H-2 petition due to collection of prohibited fees, H-2 workers are granted a 30-day grace period during which they do not accrue any unlawful presence. During this period, the H-2 worker may seek and obtain new H-2 employment or depart the United States. Second, an employer is barred for 2 years from participation in the H-2A program if it, a joint employer, parent, subsidiary, or affiliate, has violated the laws regarding the smuggling and harboring of aliens or employed an H-2A worker in a position that is not described in the petition. Third, to participate in the H-2A program, employers must consent to allow access to the employment site by DHS officers for purposes of determining compliance with H-2A requirements. Fourth, H-2A workers are authorized extensions of stay up to 2 weeks in emergent circumstances without requiring an additional DOL-approved temporary labor certification. Fifth, employers are liable for return transportation costs if an H-2B worker is dismissed from employment for any reason before the end of the period of authorized admission. And lastly, an H-2A worker on whose behalf a petition requesting an extension of stay has been filed by a new employer may continue working for that employer for a period of 120 days during the pendency of such petition if the new employer is a participant in good standing in the E-Verify program. The components of DHS combat human trafficking through a variety of efforts, including enhanced public awareness, training, victim assistance, and law enforcement investigations, and the DHS Blue Campaign coordinates and unites this work. Details regarding the Blue Campaign were provided in the OAS-IA-HCR hearing on human trafficking earlier today. DHS, through USCIS, administers the T and U non-immigrant status programs, which provide certain immigration protections to alien victims of severe forms of human trafficking and victims of qualifying crimes. As such, H-2 workers who are victims of human trafficking may be eligible for long-term relief through the T and U non-immigrant status. The T visa provides legal status to victims of human trafficking, allowing them to remain in the United States to assist in an investigation or prosecution of human trafficking. The applicant must meet the federal definition of severe forms of trafficking in persons. The U visa is available to victims of qualifying crimes who have suffered substantial mental or physical abuse as a result of the crime, allowing victims to remain in the United States and assist law enforcement authorities in the investigation or prosecution of the criminal activity. Qualifying crimes include involuntary servitude, human trafficking, and more than 20 other serious crimes. In addition to the T and U visa options, DHS may parole into the United States former H-2 workers to take part in legal proceedings where there is a benefit to the United States government in doing so. DHS may grant significant public benefit parole, SPBP, to bring an alien witness, defendant, or cooperating source and if necessary, in extremely limited cases, the alien's immediate family members into the United States for up to 1 year. Significant public benefit parole is granted for the minimum period of time required to accomplish the purpose of the request, with extensions available if necessary. SPBP requests may be submitted by federal, state, local, and tribal law enforcement agencies, LEAs. Requesting LEAs are required to adhere to existing ICE policy and procedures in both requesting and administering SPBPs. The sponsoring LEA is responsible for supervising and monitoring the whereabouts of the parolee while he or she is present in the United States and must ensure the parolee's timely departure. Further, if involved in civil litigation between two private parties, USCIS's International Operations Division Humanitarian Branch may grant parole to a former H-2 worker for the purpose of testifying in civil litigation. A request may be made one of two ways. One, a former H-2 worker may file a USCIS Form I-131 application for travel document directly with USCIS. Or two, a government agency may request parole on behalf of the former H-2 worker. Along with Form I-131, the former H-2 worker submits the Form I-131 filing fee, generally $360, USCIS Form I-134 affidavit of support, and documentation regarding the litigation involved to support the parole's request. If a government agency is requesting parole on behalf of a former H-2 worker, the agency makes the request directly to USCIS with a memo detailing the reasons parole is being requested, along with any litigation documents in support of the request. Further, the requesting agency should present an individual willing to serve as a financial sponsor for the former H-2 worker while in the United States in parole status. The financial sponsor completes Form I-134 and provides supporting financial documentation. There is no fee for a government parole request. The protections discussed demonstrate DHS's commitment to ensuring H-2 workers are not exploited through our H-2 programs. DHS continues to think of new ways to address these concerns, and the agency is always open to new ideas. We appreciate the opportunity to discuss our work on this program with you, and thank you for your interest. Thank you.
Good afternoon. I want to thank the commissioners, and I'd like to thank the petitioners for giving us the opportunity today to discuss these very important issues. My name is Michael Hancock, and I'm the Assistant Administrator for Policy for the Department of Labor's Wage and Hour Division, the agency responsible for enforcing the worker protection provisions in the H-2A and the H-2B programs. I'm pleased to be here today to talk about the department, what the department is doing to protect the rights of H-2 workers, and in particular to guard against prohibited recruitment practices. The Wage and Hour Division's mission is to promote and achieve compliance with labor standards and to protect and enhance the welfare of the nation's workforce. In the last 4 years, Wage and Hour has hired more than 300 new investigators and now has more than 600 multilingual investigators on our staff. We've also hired new community outreach specialists to achieve a greater presence in the communities with vulnerable workers. In the last 4 years, the agency has also increased its outreach and education efforts. We've created English and Spanish versions of important tools like worker rights cards and posters, plus a series of educational Know Your Rights videos distributed to worker centers and to consulates. We also rely on long-standing partnership with a number of embassies and consulates to help communicate with difficult-to-reach workers and to get back wages in the hands of workers inside and outside the United States. In the last several years, Wage and Hour has increased our enforcement activities through both complaint-driven investigations and targeted initiatives in industries where vulnerable workers are employed. When violations are found, the division is using all enforcement tools available to recover back wages for the affected workers and to deter future violations. Our agency enforces not only H-2A and H-2B labor protections, but other labor standards protecting many of these same workers. For instance, most H-2B workers are entitled to minimum wage and overtime protections of the Fair Labor Standards Act. And for many H-2A workers, we enforce the Act's minimum wage requirements as well as housing and field sanitation standards. In the last 4 fiscal years, Wage and Hour has concluded over 900 H-2 investigations, collected more than $3.8 million in back wages for 7,600 H-2 workers. While bolstering our overall enforcement and compliance efforts, Wage and Hour also recognizes the unique vulnerability of H-2A and H-2B workers to illegal recruitment fees. Prohibiting employers from passing on these costs was a particular focus of our recent regulatory changes to the H-2A and 2B programs, and allows Wage and Hour to protect workers from recruitment abuses that have the effect of reducing the workers' lawful wages. In 2010, the Department published new regulations which significantly strengthen protections for H-2A temporary agricultural workers. Employers must make assurances that they will comply with requirements of the program as a condition of certification, which includes the provision of an appropriate wage and humane and safe housing. Department-enforced H-2A protections include requirements that employers have bona fide temporary jobs for H-2A workers, pay proper wages, and not charge, and importantly, or allow their agents or attorneys to charge, workers for recruitment costs or certification expenses. Wage and Hour has stepped up H-2A enforcement and now has independent authority to debar persistent violators from this program. The Department published new regulations in early 2012 that significantly strengthen protections for H-2B workers, addressing many of the same concerns expressed by the petitioners of today's hearing about the recruitment expenses and employer misrepresentations. The Department, unfortunately, is currently enjoined from enforcing the new H-2B regulations as a result of ongoing litigation. The new regulations require that employers disclose to H-2B workers the terms and conditions of the job and provide the Department copies of contracts with its recruiters, along with the names and locations of all subsidiary recruiters. The Department will maintain a publicly available list of agents and recruiters, making the H-2B recruitment process much more transparent and assisting us, other agencies, workers, and advocates to understand the recruitment chain and the role of each participant. Also under the new regulations, employers must offer workers at least 3/4 of the promised hours, and in most cases must pay for inbound and outbound transportation. Due to the injunction, the Department continues to enforce the H-2B protections published in the 2008 regulation and the FLSA, including the prohibition on employers from charging or allowing their agents or employees from charging workers for transportation, recruitment costs, or certification expenses. Thank you for your time this morning. I sincerely hope that the information presented here has made clear the level of commitment that the Department of Labor has to protecting H-2A and H-2B workers.
Good afternoon. My name is Patrick Welsh, and I am the Director of Field Operations in the Office of Visa Services at the U.S. Department of State. I am pleased to join you today to talk about the role of the Department of State in detecting and curbing the exploitation of non-skilled workers who come to the United States to engage in temporary employment. In many respects, consular officers are the first line of defense against the exploitation of H-2 workers, which is why the Department trains consular officers to be alert to signs of trafficking and worker exploitation when adjudicating visa applications. Our embassies and consulates abroad require H-2 workers to provide accurate and complete information during the visa application process, which our fraud prevention units use to identify malified employers or recruiters before the day of the visa interview. On the day of the visa interview, we distribute to each H-2 applicant a William Wilberforce pamphlet. William Wilberforce is the British lawmaker who led a successful effort to abolish slavery in the British Empire. The law authorizing our anti-exploitation efforts is named in his honor. I have copies of this pamphlet in English and Spanish with me today. These brochures outline the workers' legal rights under U.S. and state immigration, labor, and employment laws. At the time of the visa interview, consular officers must confirm the pamphlet has been received and understood by the applicant. The pamphlet also includes information on the right of worker access to immigration and labor rights groups, the right to seek redress in United States courts, the right to report abuse without retaliation, and victim services complaint hotlines. Consular officers must also verify that the H-2 worker knows the terms of his or her employment, including details such as location, salary, living arrangements, and work hours. Officers will also probe for evidence of worker exploitation by asking the worker if he or she paid any recruitment fees or had been mistreated previously when working in the United States. If a consular officer verifies an employer or recruiter solicited prohibited fees from a worker or misrepresented material information, the officer will deny the worker's visa and return the employer's petition back to DHS for further review. In other instances, a consular officer may determine that an employer, for example, previously did not reimburse a worker's travel expenses, failed to provide acceptable housing, failed to pay worker wages, or retaliated against a worker. If an embassy or consulate confirms that a potential violation of U.S. labor or employment law took place, it will refer the employer to the Department of Labor for investigation. Unfortunately, recruiters often coach workers on how to answer questions at the time of the visa interview. Workers are afraid of losing their opportunity to work in the United States and therefore regularly refuse to cooperate with embassies or consulates in their investigations of the recruiter or employer, even those exploiting them. When possible, the embassy or consulate will also work with local law enforcement to pursue criminal cases against unscrupulous recruiters. To this end, our consular sections in Mexico provide a toll-free number for potential H-2 workers to confirm whether the recruiter has processed visa applicants in the past and whether the employer has DHS authorization to hire workers. The department also encourages our embassies and consulates to inform H-2 workers about their rights using a variety of outreach methods, including television and radio campaigns, town hall meetings in worker source communities, videos in our consular section waiting rooms, job fairs where workers can meet with bona fide employers, and distributing passport covers printed with worker rights and hotline information. Ultimately, U.S. employers and their agents have responsibility for recruiting H-2 workers in compliance with U.S. law. Together with our U.S. government partners, we will continue to work with employers to end exploitative H-2 work recruitment practices. We have come a long way in our efforts to combat worker exploitation, but recognize that there is more to do and will consider the recommendations the Commission has regarding this important issue. Thank you.
Thank you very much for the information you've both provided, the petitioners and the state. I wanted to first give the rapporteur for the rights of migrants an opportunity to offer comments and questions to both of you.
Thanks, Madam President, and I appreciate the information provided by both the petitioners and the government, and I would like to make a couple of questions. We had a hearing immediately before this one, which was addressing as a general matter the issue of human trafficking in the United States. And at that hearing, at which some of you were in the public, you might have heard that we discussed, among other things, the issue of the recruitment fees. What was told at that hearing was that according to legislation passed a few years ago, recruitment fees are not longer allowed by the U.S. law. However, if I understood well, petitioners here at this hearing have said that there is a problem with recruitment fees, and I didn't quite understood where you were referring, that the legislation is still not enough, or that there are practices in this regard that the government recognized as fighting on those practices, but that is legally settled the issue. So I would like more clarity on this matter regarding the H-2 visas migrants. And the second issue that also it's been taken from the prior hearing applied to this one for the H-2 visa persons with H-2 visas is the one referred to legal aid. because I asked at that hearing about the legal aid for this for the persons who were victims of human trafficking. And now I would like to ask the same question to the government, but specifically refer to persons who hold an H-2 visa, where they can apply for legal aid, or this mechanism that was explained at the prior hearing of providing funding to NGOs that can provide them the legal aid is applicable also to these persons. Thanks.
Thanks, Commissioner Gonzalez. I wanted to ask a couple of questions, particularly to the state. One was about the T and U visas. Is that correct? There are two. And to just find out how many H-2 visa persons who entered on H-2 visas have ended up receiving any of these visas on the basis of the oppression or trafficking which they experienced. So just to have an idea of whether this other avenue for addressing the human rights violations of H-2 visa workers is actually being utilized. The second was to get a better sense of what happens if a recruitment fee is actually used. So what I hear the petitioners saying is that it's illegal, but they're still doing it, the enforcement is poor. But the sense I get is that if you find out there's a recruitment fee, you don't give the visa. And my sense is that for a poor migrant worker, that's essentially a form of punishment. You know, that's effectively giving the person what they don't want. And so what I heard the petitioner saying is that you have to create some incentive for whistleblowing. So you have to create a set of mechanisms which would encourage the potential H-2 visa applicant to want to tell you that there's been a violation. And what in fact I do hear are disincentives, because the denial of the visa is a disincentive to saying something wrong happened in the process, given the imbalance of power. So I wondered whether you could respond specifically to that question raised by the petitioners about creating incentives in a system where it's a migrant worker and extremely vulnerable and powerless can actually make the complaints. Obviously, legal aid is one of those, but there are others which they mentioned: immigration relief, the capacity to change employment, and so on. I wanted to ask about those. Can I first, in the interest of time, give the petitioners a few minutes? We know we haven't asked you specific questions, but you might still have observations for about 3 or 4 minutes, and then the state.
Thank you, Commissioners. I want to briefly touch on the important question that Commissioner Gonzalez has raised about legal aid. As we've raised in prior communications with the Commission, H-2B workers and undocumented workers are not entitled to legal aid from Legal Services Corporation funded organizations, which is really one of the only mechanisms available for legal aid to workers. So not only are H-2B workers whose right to be in this country has been approved by 3 departments of the executive branch not entitled to receive legal aid representation, workers who are retaliated against and lose their job on either the H-2A or the H-2B are no longer in lawful visa status, and they then become undocumented and also are entitled to Legal Services Corporation funded representation, significantly undermining their ability to obtain legal aid. I'm going to turn it over to Rachel Micah Jones to answer the question on visa fees.
Thank you, Commissioner Robinson. You're exactly right. There is a fee ban. The Department of Homeland Security issued regulations that did prohibit the paying of fees, and we heard from our colleague at the Department of Homeland Security a lot of the language in that fee ban. But the effective remedy is that the visa petition gets denied. So there is a disincentive for workers to come forward, and in practice, 58% of the workers we interviewed for the Recruitment Revealed study paid a recruitment fee. And the average fee paid by workers since 2009, that's post the recruitment fee ban, was $590. And that does not include transportation, visa, and a whole host of other fees and costs that are charged to workers during the recruitment process. We do believe that there would be more effective and practical ways of providing or enforcing the recruitment fee ban.
Can I give the state an opportunity as well to respond to some of the specific questions we had? Of course, there may not be enough time, so we welcome receiving in writing information as well.
If I may, Commissioner Robinson, you hit on one of the real impediments to effective enforcement, and that is the fear of the workers. If they come forward, the consequence is that they're not going to get the job that they had paid for, in essence. And it's a real problem, I think, for every enforcement agency, whether it's DHS, state, or the Department of Labor. It's not a perfect solution, but once the workers are here and Wage and Hour engages in enforcement action, we do so in a way that it's not, we don't have to have a complaint, so it's harder for the employer to identify somebody as being a complainant and retaliate against them. And we can do it in a way that at least gives them some comfort that they're not going to be exposed as somebody that complained about unlawful recruitment. It's not perfect, but it does give us some ability to do that.
Yeah, thank you very much for the questions. A few thoughts in response from the DHS side of things. Regarding the number of H-2As and H-2Bs who have benefited from the TNU program, I don't have those figures handy, and I do not know whether USCIS tracks that information, but we'd be happy to investigate and provide you whatever data points that we have on that question. Regarding the incentives and disincentives that you have discussed, we also appreciate the difficult position that these individuals who are attempting to benefit from this program, which of course intends to be in large part for their benefit, it creates challenges and difficulties for them. And a few thoughts in terms of where I suppose the agency is coming from and incentives that we do hope to create, although recognizing that perhaps more work can be done and that the solutions are not ideal. For one, we of course hope that by prohibiting or precluding an employer or a recruiter from involvement in the H-2 program and denying their petitions, that will protect future workers from being abused by these same recruiters and employers. It's true that the immediate individuals involved might face repercussions, but future flow of workers might benefit from the attention shed on these recruiters and employers. Also, if there's good actors on the petitioner side of things, then a repayment or reimbursement can be made to the worker, or the agreement can be terminated that would result in these fees, and that would result in the petition not being revoked or denied, and would allow the worker to continue to engage or obtain or seek to obtain that employment. A couple other points, and I know I touched on these points in my statement, but if a petition is revoked while the worker is here and he or she thus loses their employment under the H-2 program, they are provided with a 30-day grace period during which they will not accrue unlawful presence, can seek employment with another H-2 employer if available, and will not be counted in the H-2B context against the H-2 cap. And those are a few of the thoughts that I had in terms of the disincentives and incentives, but again, respect the considerations that you brought to our attention.
I want to express my gratitude in closing this hearing to the petitioners. You've made some specific requests which the Commission will consider. You have with you the Rapporteur for the United States and migrants, so we both have the ability to give some thought to this. I also want to take note of the state's interest and commitment to following up, and interest in the Commission's role in continuing to monitor this situation. We're thankful for the detailed information you provided. The state has indicated that there is additional information which you hopefully can share with us after, and we welcome that. Thanks to everyone.